The Waitangi Tribunal has started the Y3060 Justice Inquiry, looking at the New Zealand justice system in its entirety. The landmark inquiry includes claims, prison programs and the treatment of prisoners, police conduct, courts and inequities in youth justice. We asked Te Mata Law Principal David Stone why this inquiry is such a big deal.
When you look at the position of Māori right now, in terms of the statistics everywhere, and by that I mean prisons, oranga tamariki, lining up outside government departments, all that sort of stuff. As we know, and it's no surprise, and it's not new news, that Māori are disproportionately overrepresented everywhere. And so why is this important? It's important because it gives us an opportunity to address the underlying issues as to why Māori are filling our prisons and so on.
Well, there are obviously claims, right? What sorts of claims have been filed? What are we looking at here?
Well, the claims that my office and I have filed, we've gone right to the very beginning. And by that, we've filed claims in respect of the police themselves, how they conduct themselves, how we know there is an inherent bias within the police themselves, how they talk and handle our people, because we know that all things being equal, if you've got a Māori and a non-Māori standing there, we all know that the Māori guy is more than likely going to be in prison than the non-Māori. And from there, we look at the court systems itself, how it's alienating to our Māori people, how our Māori people don't get real access to justice. By that I mean access to legal representation. We look at the attitude of the judges themselves and how they deal with Māori. And again, like I just said, we know that the police are more likely to arrest Māori than a non-Māori, and we also know that a judge is more likely to sentence a Māori to prison time than a non-Māori. And then once they're in prison, we're looking at how they're treated inside, how they don't get the services that they need. And by that I mean we know that a lot of our Māori people have been sent into prison when they have drug and alcohol problems. We look at the programs and services and care that they get. A lot of them don't get the care that they need to help them, not just to rehabilitate themselves from their drug and alcohol problems. We know that they don't get the care they need. Soon after their release, they reoffend again and they're back inside. And so we're also looking at the care they get once they're released and everything in between. And that's just the prisons. There's other areas as well. We're looking at oranga tamariki again. We know from the urgency application that we filed for the Hastings uplift, as it's become to known.
David,
that was for answer clear.
What outcomes are claimants hoping to gain from participating in this inquiry?
I had a phone call from Rumataka just yesterday, and I said to him, this inquiry isn't an opportunity for you to have an appeal on your case. We're hoping to highlight what happened in your case, to highlight the systemic failings, in the hope that those failings get addressed and remedied so that future Māori who find themselves in a position like this particular client doesn't experience what he experienced. And I said to him, if you're happy with that, we'll file your claim. And he was, knowing that the benefits will come further down the track.
And how challenging has it been for you to hear some of these claims?
Really challenging. I mean, I've received instructions just yesterday from a cousin of mine who was put inside, who was physically assaulted very badly, was mutilated inside, and all sorts of really, really terrible stuff. And it is challenging and it is hard, but that's how it is.
Te Mata Law Principal Lawyer David Stone, thank you so much for joining us today. Ngā mihi.
Tēnā koe, Neil. Kia ora.